All right, good afternoon, ladies and gentlemen. My name is Matt Green. I'm president of the Mobile chapter of our local Federalist Society. We are the Brevard Hand Alex Howard chapter. The Federalist Society is a nonpartisan, conservative, and libertarian organization dedicated to freedom, federalism, and judicial restraint. The Federalist Society seeks to educate the legal community through its programs and publications about how limited constitutional government based on the rule of law can have a positive effect on law and public policy. It is founded on the principles that the state exists to preserve freedom, that the separation of governmental powers is essential to our Constitution, and that it is emphatically the duty of the judiciary to say what the law is, not what it should be. The Society seeks to promote an awareness of these principles and to further their appreciations through its activities. We are very fortunate to have Professor John C. Eastman today to speak to us today. His presentation is entitled Live by the Executive Order, Die by the Executive Order, an analysis of the Obama and Trump immigration executive orders. Professor Eastman is a Henry Salvatore Professor of Law and Community Service and former Dean at Chapman University's Dale E. Fowler School of Law in Orange County or Orange, California. He is also the founding director of the Claremont Institute's Center for Constitutional Jurisprudence, on whose behalf he's actually appeared before the Supreme Court hundreds of times and in ways of filing amicus as well, always touching on issues of constitutional importance and significance, particularly with those principles that we at the Federalist Society hold very dear. And speaking of which, he's also, I believe you are the chair of the Separation of Powers thank you, of the Federalist Society. He's also a former law clerk to Justice Clarence Thomas. Professor Eastman also has a PhD in government from Claremont Institute, our graduate school. He's a JD from the University of Chicago School of Law. He, as I said, he's chairman of the Federalist Society's Federalism and Separation of Powers Practice Group. He's been a frequent expert, testified before Congress numerous times. He's been on the radio, C-SPAN, television, Fox News, PBS, O'Reilly Factor, you name it. Please join me in welcoming Professor John Eastman. Thank you very much.
Thanks very much for having me, Matt. And I'm delighted to be here in Alabama, the home of what the Northeast liberals affectionately referred to as unlearned and Jeremiah and the brother, the great learned scholars of what the Constitution really said. And I'm also here because my wife and I are now visiting the Gulf Coast with some frequency. My son has relocated here. He's now an engineer down at Ingalls Shipbuilding, and there's a big christening down there tomorrow. He told me, and it's the ship, the one iteration before the one he's working on. And he said, this is your opportunity to see what I'm doing. And so we decided to come down for that. So I'm grateful for the opportunity to kind of sneak over today and talk to you all. You know, there's a lot going on with executive orders, and there's a shoe on the other foot type of all of the argument. So for the last 8 years, a lot of people on my side of the political aisle were critical of President Obama's use of executive orders, and most of us have been strangely silent about President Trump's use of executive orders. And similarly, on the other side of the political spectrum, they were all big defenders of executive orders back then, and there's nothing that this president can do by executive order or anything else that doesn't raise all sorts of hues and cries of illegal, illegal, and unconstitutional. I'm going to try and look at it a little more nuanced than that, because I think President Obama issued some executive orders that were well within his authority, even if I thought they were really bad policy judgments. And then he issued some that I believe were patently illegal and or unconstitutional. And I've been watching very carefully the current president to see if I can make similar things there. So far, his use of the executive orders, I think, have all fallen well on the perfectly lawful side of the line. But I'm not hesitant to criticize when they do that. President Bush's executive order in 2008, for example, in the middle of the financial crisis, Congress passes the TARP, the Troubled Asset Relief Program, it was almost $1 trillion to help bail out the financial industry. And Bush said, oh my gosh, we've got a problem over in the car industry as well. I want to use some of those TARP funds for the auto industry, but the statute didn't allow for it. And he asked Congress to amend the statute, and the House
passed the bill, but the Senate didn't. And so the bill failed, and that meant there was no legal authority to transfer some of those funds over to the auto industry bailout. Bush did it by executive order, and I was very critical of that. So I think it's very important to kind of back away from any, do I like the policy judgment? Do I think, whatever advancing, or is it my guy doing it rather than the other guy do it? And look at the assessment and the legal issues. Now, I'm going to start with the issue that is before the Supreme Court right now, and that is the president's authority to block immigration to this country. Now, the president, after making factual determinations that certain countries in the world had become harbingers of terrorism, revoked their ability to participate in the visa waiver program. And that law was based on a statute from Congress adopted in 1952. And let me just read it for you, because I think it's fairly unambiguous. Section 1182F of Title 8. Whenever the president finds that the entry of any aliens or class of aliens into the United States would be detrimental to the interests of the United States, he may, by proclamation, and for such period as he shall deem necessary, suspend the entry of all aliens or any class of aliens as immigrants or non-immigrants, or impose on the entry of aliens any restrictions he may deem to be inappropriate. Now, the president relied explicitly on that statutory provision, so you had combined whatever authority he had on his own powers under Article 2, plus an explicit delegation of power from the Congress to block this group of immigrants. And the 7 countries that the president listed, 2 of them had been designated by Congress itself, Iraq and Syria. The others were designated after a formal determination by the president or through his Secretary of Homeland Security or by the Secretary of State. There are different statutory provisions that they had repeatedly supported acts of international terrorism, or that they foreign terrorist organizations had a significant presence in the country, or the country had become a safe haven for terrorists. Those designations were made in accordance with the statutory program set out, and anybody coming from those 7 countries was prohibited from participating in the visa waiver program. There's not a single word of the illegality of that, because the president I'm talking about is not President Trump that did that, it was President Obama. President Trump takes those same 7 countries that he didn't designate, but that had been designated by the Secretary of State and Secretary of Homeland Security in the prior administration. Secretary of State, yes. And he then says, okay, not just removing you from eligibility for the visa waiver program, we're going to ratchet it up a notch, and we're not going to allow you to apply for visas at all. For those that are already here on a temporary basis, we're going to review the issuance of a visa and possibly revoke it if we think that you're connected in any way to these terrorist organizations. There's another statute that's very clear, Section 1201 of Title 8. The Secretary of State may revoke any existing visa at any time in his discretion, and there shall be no judicial review of that decision to revoke the visa. Okay? Now, so the president clearly had statutory authority to do what President Trump did in the so-called Muslim ban, which was a temporary suspension of the visas and immigration. And it gets up to the federal court in Seattle. It's a little bit different than I think the federal court in Mobile or Montgomery or what have you. And that judge issues a nationwide injunction against Trump's executive order. Now, you would think, when statutory authority and precedent so clear and unambiguous, that he would at least make some effort to come up with an argument why it didn't apply, or why it didn't mean what it quite evidently appears to mean. And go look at that opinion. He doesn't cite this statute. He doesn't cite any of the Supreme Court or District Court or Federal Courts of Appeals decisions applying this statute. This is not a brand new statute. It's been around for over 50 years. In fact, when President Carter relied on exactly the same statute to withhold the issuance of visas to people from exactly one of the same 7 countries, Iran, after our embassy in Tehran was taken over, he did exactly the same thing, and he did worse. He applied it to rescind visas from people who are already here in the United States. There was a group of Iranian students studying at Michigan State University who, at the moment that that order came down, were on a field trip up in Canada. When they sought to re-enter the United States at the border, they were denied entry. They had no advance warning that this came down very quickly.
No notice and opportunity.
No notice and opportunity. They litigated it. It didn't go all the way to the Supreme Court. It did go to the District Court, U.S. Court of Appeals for the District of Columbia, and they upheld the president's authority here on grounds very similar to the Supreme Court's decision in the old Curtis Wright case. One of the issues is this delegating lawmaking power to the president, because it says, whenever he wants to do this in his discretion, if he determines that it's necessary for the national security. That doesn't sound like it's a very intelligible principle on what to confine the president. But similar with the old Curtis Wright case, the president was delegated the authority to block arms sales to either side in the civil war going on down in Bolivia back at the time. And the court said it didn't matter that Congress had a statute authorizing this. It's not an illegal delegation of legislative powers, because in the foreign affairs arena, the president had this power anyway. It's one of the incidents of sovereignty that we've placed in the authority of the president to decide who gets to enter the United States. Now, the legislature has a role as well, but quite clearly, that's what the D.C. Circuit said. The people are still wringing their hands. There's a movie about it you can catch on Netflix called Checkpoint. But those students were not allowed re-entry back into the United States. That's the precedent on clear authority. Neither the cases, neither the statute, or any of the collateral statutes that clearly give this authority to the president were even mentioned by the lower courts in this. They're not mentioned in the Maryland case and the Hawaii cases on the second iteration of this executive order that are heading up there as well. However, I do think we've got a pretty good indication of what's going to happen, both with the seating of Justice Gorsuch and also the Supreme Court's decision back last June issuing a stay of the lower court order that had enjoined the president's enforcement of this. And it'll be heard first week in October, so we'll know a lot more about it. A lot of this is going to turn on what Justice Kennedy does, but if you look at some of his opinions from last term, there was a case dealing with one of the old material witness detentions from right in the aftermath of 9/11. And the guy had brought a Bivens action against the Attorney General and what have you for illegal detention and then all sorts of allegations about what happened to him while he was in detention. Justice Kennedy writes an opinion for the court saying that there's no Bivens action and we got to dismiss this case. And that's a pretty common resolution of these Bivens actions in new areas that the court had not recognized Bivens claims in before. But he didn't stop there. He could have, but he didn't. He goes on and adds a whole other section of the opinion talking about the role of the president in foreign policy and national security issues that are largely immune from judicial review. That was completely gratuitous, but it does give a pretty strong indication where Kennedy might come down. Now, it was Kennedy, so there's, fluffy language that, if he wants to go the other direction on this one. What's the movie recently out, Guardians of the Universe? I get this sense that Justice Kennedy thinks he's the guardian of the universe. And that, that nothing good will come of it if it isn't vetted properly by him. And so, so he may want to vet the president's decision here and decide whether he agrees with it or not. But the law is very clear. Now, there is a statute that was adopted in 1965, says that when we're doing our immigration policy, we can't discriminate on the basis of religion or ethnic background or national origin or place of origin. And some have argued that statute preempts or overturns the prior authority of the president. But and so one of the other things you saw in the last term with Gorsuch and some of the others is the court increasingly doing very careful textual analysis to try and reconcile what otherwise might be deemed to be conflicts in the statutes. And the 1965 statute deals with the broader visa immigration program. 1182, the one I read to you earlier, deals with the president's determination on who gets to enter. The mere issuance of a visa does not guarantee your entry. So the two statutes are perfectly compatible. Yeah, you can't discriminate against these 7 countries on the issuance of a visa, whether that even applies in this context, because it's not based on your national origin in that country. It's based on those countries being, harbingers of terrorism. I would say it's not covered by that statute anyway. But even if it was, it would only affect the ability to get a visa, not to use that visa to enter the country, which is exclusively the president's authority under his Section 1182. So I think on that set, I think the president's in pretty good shape, and the careful textual analysis that 5 members of the court seem willing to engage in on these questions suggests to me that he probably ought to win the case that's pending up there right now. Now, there are a couple of other issues, and then I'm going to get to the granddaddy of the dispute between Obama and Trump on the DACA and DAPA programs and those executive orders. But there are a couple of other issues I want to talk about that have gotten a lot of notoriety under President Trump. So the first is the insistence, which may have blown up this week in all the controversy over the border fence. I remind people that we actually have a law on this subject as well. The Secure Fence Act of 2006 says that the Secretary of Homeland Security, quote, shall provide for at least 2 layers of fencing along the entire southern border of the United States. Now, it barely passed. Among those that have supported this overwhelming majority that voted for the Secure Fence Act of 2006 were then Senator Barack Obama and current Senator Schumer. I keep reminding them of that when I see. All right, now, the other big controversy is over the Sanctuary Cities executive order. We haven't seen that play out yet. And it's not really executive order, it's more a determination of who's eligible for various federal grant programs. There is, on this issue as well, and I go back to my other hat with, head of the Separation of Powers Practice Group, when we pass law, it's the stuff that Congress actually does, not what the executive would like them to do. So we have a sanctuary cities prohibition in federal law. It's Section 1373 of Title 8. State and local governments, quote, may not prohibit or in any way restrict any government or government official from giving or receiving information from the immigration services regarding the legal or illegal status of any person in their custody. I mean, that's what the law says. And we've got in my state, we've got to be providing the rest of the country a lot of entertainment in California. And I'm not talking about the stuff that comes out of Hollywood. I'm talking about the stuff that comes out of Sacramento, where you used to live, right? So we've now got sanctuary cities up and down the state. LA just added to it. It's going to cost us $200 billion or some ridiculous amount of money. The state of California, I think about a quarter of our budget is now at risk because of this nonsense. But San Francisco, for example, specifically says to their any employee in the government of San Francisco that you may not provide any information to the INS. And this one says you may not prohibit or in any way restrict any government official from giving information to the INS. I mean, it can't be a more bald-faced violation of that law. And their litigation position has been that, well, no, we've only dealt with giving them information about the release from prison, not about their immigration status. So the law really doesn't cover that. I mean, it's just utter nonsense. Nevertheless, we got federal and state judges who seem to find a way to uphold that agenda whenever they want. But what the administration has done on this is simply, if you're going to apply for the burn block grants for local police, we're going to make it a condition of the grant that you comply with federal law. And if you're not complying with federal law, you're not going to be eligible for the grant. Very simple. We get, oh, that's an unconstitutional condition. You're commandeering our officials. No, I'm allowed to commandeer you if it's a condition on the federal funding. It was basic commandeering law 101, right? This is one of the exceptions to the Prince decision about prohibitions on commandeering of state officials. You want the money, you gotta, give us the information that we're in part giving you the money for. It's pretty simple. I don't give you a grant to build a road and then let you, expand your living room in your house with it. I make the condition and you got to comply with it. So I think when those issues get pressed, Not in the lower courts, because Trump's already lost the first skirmishes there, but when it gets to the Supreme Court, I think he'll win there as well. The statutory authority is pretty clear. What the federal district judge in San Francisco did on this one was say, well, and relying on the Affordable Care Act decision, the amount of money that's at risk is so great that it's coercive, that you're forcing them to kind of comply with this. And the Department of Justice said, no, it's not. It's only this one grant program. We're not taking away Medicare funding for the San Francisco residents. Well, I interpret your order differently than that, and I read it as broadly as I can, so that then I say it's too broad and I strike it down, rather than reading it narrowly to meet constitutional muster, as most judges do with their courts, with their decisions. Okay, so those are the Trump executive orders. I'll then turn to the Obama executive orders on DACA and DAPA, and then I'll come back around and conclude with Trump's, or Attorney General Sessions' recent decision on the DACA stuff. So President Obama, it's not even an executive order. It's a guidance memo from Janet Napolitano to the line officers of the Immigration Services about how they're basically being ordered not to put into deportation proceedings anybody who meets a selective set of criteria spelled out in the memo. The memo is written by some lawyers that know that you can't just suspend the law in the use of prosecutorial discretion. You've got to visit these things on a case-by-case basis, right? Isn't that the kind of prosecutor's discretion? And so the memo is full of things. You shall do this on a case-by-case basis. But then, but the case-by-case language is just thrown in there. It's patently clear to everybody that anybody that meets the criteria is eligible for this deferred action status and almost entitled to it. In fact, that's the way it was sold. And President Obama, apparently not listening to his lawyers, when he went out and gave a speech about this, said, somebody asked him, well, if it's discretionary, can't your border officers decide to still put somebody in removal? He said, well, they might try, but they'd be fired because this is an order, right? So, and I testified in Congress on this subject, and one of the people testifying at the table with me was one of the so-called dreamers. She goes, I have a legal right to this now. You can't take it away from me. So the Obama administration himself saw it as a mandate. The line officers clearly did, the people that were recipients of it. And that's changing the law. That's not exercise of prosecutorial discretion. And the Supreme Court's been pretty clear on this. All the way back to, there's a case in 1838, I love this one, where there was some argument that the president could direct people not to enforce the law. To contend that the obligation imposed on the president to see the laws faithfully executed implies a power to forbid their execution is a novel construction of the Constitution and entirely inadmissible. All right? Now, how do you enforce that? And so it's long been kind of hands-off. Courts won't review decisions of prosecutorial discretion. If I decide to bring a case or not bring a case, that's pretty much a non-justiciable question, right? The way it's been handled. But in 1985, the Supreme Court recognized that at some point there's a line that gets crossed, and that judicial review of exercises of enforcement discretion could be obtained in cases where the agency has adopted, quote, a general policy that is an abdication of its statutory responsibilities. So there's a line between prosecutorial discretion and categorical suspension of the enforcement of the law.
For your take care clause?
Yeah, for the take care clause, yeah. And so now the court has never really defined where that line is, and quite frankly, I think there's a really good reason for that. If the case went up to the Supreme Court, this was when Texas brought the lawsuit against DAPA. Alabama and 25 or so other states were part of that litigation. DAPA and DACA, but for the heartstring different sets of illegal immigrant classes, the legal authorities for both of them are identical. They either both fall or they both stand on the same legal analysis. Texas brought the suit against DAPA only, I suspect, because you didn't get, all of the former 8-year-olds, yeah, you didn't, right? But the legal analysis is identical. The lower courts in the Southern District of Texas and then in the Fifth Circuit on the DAPA case technically only held that it was a violation of the Administrative Procedures Act because they did this massive change in policy without going through notice and comment rulemaking. That's the technical narrow holding. That's the only thing that the Supreme Court affirms by its 4-4 equally divided vote a year ago, all right? But in both of the lower court decisions, the opinion goes on much further to elaborate on the statutory and constitutional challenges to what Obama did. And there's no doubt that either the district judge or the 3-judge panel thought that what Obama did here was unconstitutional, even if he had done it through the Administrative Procedure Act's proper procedures. And so the issue there, has this amounted to a categorical suspension of the law? You know, I could see why the courts are having trouble with that. So what, instead of 6 million people, let's look at DACA and DAPA together, he was only going to make it 5 million, still enforce the law against 1 million. Or what if it was only 4 million or 3 million? Which point on that goes from prosecutorial discretion to categorical suspension of the law? I'm guessing that if that issue ends up back at the court, that's going to be one that they say, we don't know how to draw that line. That's a non-justiciable political question, right? I can see that. But there are 2 other aspects of Obama's order that don't suffer from that problem. One is, he's not just declining to prosecute. Prosecute, I'm using loosely. It's not even a criminal matter. It's a civil matter. He's not only declining to institute removal proceedings against these folks, but he is pretending to treat them as though they are lawfully present in the United States. Now, they avoid the word lawful status, because that's statutory. So they come up with this new phrase, lawfully present, and pretend that it doesn't mean exactly the same thing. But by giving a lawful presence or deeming them lawfully here in the United States, he's doing more than just exercising prosecutorial discretion. So think about, on the highway over, I'm going to confess, this is new. I sped a little bit, maybe a couple miles over the speed limit. At one point, I realized there was a sheriff sitting right along the road, and I looked down and it was only going 67 and it was 65, and I thought, phew, I'm okay. I was breaking the law, and he exercised prosecutorial discretion and didn't pull me over, partly because I was going 5 miles slower than everybody else. But prosecutorial discretion. That did not give me a legal entitlement to continue going 67, and if the next sheriff down the road wanted to exercise his prosecutorial discretion in a different way, I could have gotten a ticket. Right? What Obama did here was to make it sound as if prosecutorial discretion actually allowed me to treat unlawful conduct as though it was lawful. Right? That's no part of the exercise of prosecutorial discretion.
But he's a constitutional law professor. He knows the Constitution.
That's right. He knows the Constitution. I'll tell you a story. Well, he was a constitutional law lecturer, not a professor, at my alma mater while I was there. And I came to law school with already a PhD in American political thought and American political history. So I took every constitutional law class that was offered, and his was never on the general roster of classes. They handpicked students that they knew wouldn't give them any grief. They claimed them. Anyway, that's another story altogether. Okay. Now, pretending that it's lawfully present goes well beyond the authority here. Now, the third piece of it, which is even more egregiously illegal, is once they deemed them as lawfully present, they said, well, anybody that's lawfully present in the United States is eligible to get work authorizations, and therefore Social Security numbers, and therefore Social Security benefits, and that triggers Medicare and Medicaid benefits, and it triggers eligibility for earned incomes tax credits, all retroactive 3 years for the statutory limitations on refiling tax returns. This was a multi-billion-dollar raid on the federal treasury in direct contradiction of statutory eligibility for those programs. And so it violates Article 1, Section 9 that says, all appropriations have to be authorized by an act of Congress. And yet we're doing this. And I'm not the only one that has seen this problem. You go back and you look at the Clinton administration, even all the way back to the Carter administration, on this question of prosecutorial discretion. I'm looking for the exact quote, and I'm not finding it off the top here. But it says, whatever power for prosecutorial discretion exists, that doesn't allow you to give out benefits. That's a thing different in kind than the decision not to prosecute somebody. So we've got all sorts of problems with that Napolitano memo, and it became patently clear from the get-go that she had crossed whatever lines were there. And so across the country, there are legal scholars trying to find some statutory hook that would allow her to give out these work authorizations. And they finally settled on this, a regulation, not a statute, but Section 274A.12 of Section 8 of the Code of Federal Regulations. And this is the class of aliens who are authorized to accept employment authorizations. If they have a legal status, and there's that word status instead of lawful presence, lawful permanent residents, people, green card holders, or whatever. If they have specific employers under like the H-1-9 visa, the whatever, there's a specific mechanism for that. Spouse or children of foreign government officials, a couple of things, asylum seekers, a couple of things specifically set out. And then there's this subparagraph 14, an alien who has been granted deferred action, which is an act of administrative convenience to the government, which gives some cases lower priority, if the alien establishes an economic necessity for the employment. All right, so, we found a place that would authorize the issuance of these work authorizations. Problem is, you've got to establish an economic necessity. And it's got to be different than just, I need to work, because everybody needs to work. There's got to be something extraordinary thing that has happened that makes it different in kind than just, I gotta earn a living. That's D.C. Circuit precedent. They ignore all of that. Plus, this is a regulation. It's not based on any statute. The regulation cites authority 4 different statutes. One of them deals with immigration from the Northern Mariana Islands, so I think we can get rid of that. The 2 of the other 3 were just statutory definition sections. And then there was the work authorization statute, section 1324A. And that's the one, it doesn't give authorizations, it makes it unlawful to hire people who are not in this country legally. It says it's unlawful to hire or recruit for employment any alien knowing the alien is an unauthorized alien, as defined in subsection H3. Let me get into the weeds a little bit, because you can see how manipulative these guys were. So subsection H3 defines unauthorized alien as this. As used in this section, the term unauthorized alien means, with respect to the employment of the alien at a particular time, that the alien is not at that time either an alien lawfully admitted for permanent residence, here's my LPRs, my lawful permanent residence, or authorized to be so employed by this chapter, and those are all the statutory exceptions I just referred to with specific criteria, and then, or by the Attorney General, right? So they've now read that last 5 words, or by the Attorney General, as given the Attorney General unfettered discretion to give out work authorizations whenever he wants. And then another statute post 9/11, the Attorney General's authority over these things was transferred to the Secretary of Homeland Security. So they're claiming we have the legal authority under this statutory phrase to give out work authorizations whatever we want. So it's not an exercise of prosecutorial discretion, Eastman. We've got statutory authority that we're just implementing. Now, you go back and you look at that phrase. So the first part of it, or so employed by this chapter, refers to the various very well-honed and hotly fought over statutory exemptions allowing work authorizations in this country with specific criteria there. There are 3 or 4 other statutes in the massive set of immigration code that give the Attorney General a similar type of authority to issue exemptions. Is the person helping us with a major international drug trafficking or human trafficking criminal prosecution? I can give them an authorization to stay here and to work. But there are very specific and narrowly tailored criteria. That's what that language is referring to, the Attorney General's other authorities. But to read it the way Obama did is to basically say, the Attorney General had this discretion all along. It's unfettered. There are no limitations on it, no intelligible principle to guide the delegation of this massive amount of lawmaking power. that was added in 1986 without one word about this being the idea behind this for language. You would have thought if that was what they were doing, there would have been a little bit of dust kicked up in Congress over this, because they were fighting bloody wars about all of these other statutory exemptions, which become meaningless if this phrase means what it says. We don't have much of a non-delegation doctrine left, because they've said, go forth and regulate in the public interest is enough of an intelligible principle to meet the requirements of Article 1's non-delegation doctrine. But this one doesn't even have that. So maybe if we press this right, we get our non-delegation doctrine back. That would be good. Anyway, so a couple of things in conclusion on this. I think the categorical suspension of the law was itself beyond the scope of prosecutorial discretion, but I acknowledge how difficult it's going to be for the judges to figure out that line. But the awarding of a lawful presence, and then beyond that of actual benefits, is well beyond the constitutional authority unless you distort the meaning of the words beyond any recognition. As Judge Jerry Smith on the Fifth Circuit said, we tend not to hide mountains in molehills of language like that. That was a wonderful footnote he had. All right, so the status of DAPA is it's illegal by court order nationally enjoined. DACA is not nationally enjoined, but it suffers from exactly the same legal flaws, and the states that filed the DAPA suit were about to file the DACA suit. All right, so now enter Trump, and he says, that DACA program is illegal for all the reasons I just set out. We're going to revoke it. Within days, Secretary Napolitano, now from her perch as head of the University of California system, files suit against President Trump. And the suit is just priceless. President Trump can't revoke DACA because he didn't go through the Administrative Procedures Act. I mean, we've got to redo our dictionaries and put her picture next to the word chutzpah because it's just extraordinary. Oh, and the second claim, there are two claims in it. They violated APA, and this is Covington and Burling doing this litigation. They ought to be ashamed of themselves for what they've done here. Unfortunately, they will win in the Ninth Circuit out there, I have no doubt. But the second part of the claim is that they have a legal entitlement to this status and the renewal of the status. And University of California has a reliance interest on them being here because they're paying us some tuition. You can't revoke that without violating due process. Even though the memo itself says at the bottom, there is no legal entitlement to continue this. It can be revoked at any time. So, the chutzpah of that litigation is just astounding. Now, politically, I think the president is probably, even if he doesn't get an act of Congress that gives protection to the dreamers, I think he's not going to enforce this. So there's a real big question whether their case is even ripe or not, because all he did was revoke the memo. He hasn't revoked the deferred action certificates they all have. And he's extended it past 6 months and said, we're not going to revoke anybody in the interim whose 2-year or 3-year certificate expires and they need a renewal. We're going to keep giving them renewals. So there's nothing really at issue yet. That's not going to stop the San Francisco Federal Court from enjoining this thing nationwide and the Ninth Circuit from affirming it. But the Department of Justice lawyers are now in place, and as we learned with the Hawaii case dealing with the so-called Muslim ban litigation, they are prepared to ask for emergency relief from the Supreme Court, and the Supreme Court seems prepared to grant it. Now, Justice Kennedy on Monday, when he granted the Muslim ban relief, because the Hawaii court had said, you've got to allow everybody in under the Supreme Court's prior order from last June who are related to these folks, not just children, spouses, and parents, but third cousins, fourth cousins. They just say cousins. I'm his cousin. Imagine the Syrian say, oh, I'm the cousin of that Syrian over there. And the Hawaii court said that. So Justice Kennedy on Monday enjoined the Hawaii interpretation, but invited them to file a reply by yesterday. And Neil Katyal is handling Hawaii's litigation. Neil Katyal was Solicitor General into the Obama administration. So we'll see what Kennedy does with that or what the court does with it when it gets up. But that's kind of the state of the law there. But the notion that the president even if it was an exercise of prosecutorial discretion, can't exercise the discretion in the other direction to actually start enforcing the law as it's written, and that in order to do that, he has to go through the Administrative Procedures Act before he revokes something that did not go through the Administrative Procedures Act is really bizarre. And yet that lawlessness or that manipulation of the law that the lower courts, at least out in my coast, have become complicit in, seems to have quickly becoming the norm rather than the exception. And that, it seems to me, poses a much graver threat to the separation of powers and the rule of law than even the particular policies at issue here, which I do think are very significant. But that willingness of the courts to join on with this lawlessness. I published an article in the Hill newspaper on Capitol Hill describing what the Ninth Circuit did in the prior round as a coup. Because what's going on here is a refusal to recognize the results of the last election and the person who gained authority to make these decisions in the executive as a result of that election. And it's a really troubling thing. And so it seems to me that as members of the Federalist Society, whose mission is to advance the notions of the rule of law and not the raw will of men, that we ought to be raising the red flag about what's going on here every opportunity we get. All right, so that's my commentary on the executive orders. I hope you enjoyed it. Thanks.
And even I don't remember which litigation it was, but it was that same Southern District in Texas where the prosecutors, the Department of Justice got in significant hot water with the judge for misrepresenting things. And didn't the judge order the whole Department of Justice to mandatory CLE training on professional conduct?
He did, and so you get the DAPA program, and they represent both in oral argument and in their briefs that it is not being implemented and won't be implemented until next February, pending resolution of the court's order on Texas's application for a temporary injunction. That was not true, and they knew it was not true when they made those representations. Now, so they should have been sanctioned. My problem with the district judge sanction order was it applied to the department overall, not to the particular lawyers or the lawyers' bosses who were ordering them to do this. I would have gone after them, and it was a toothless sanction. I mean, I would have imposed monetary sanctions on the orders. I would have demanded that they to produce all the correspondence from their superiors that led them to do this, and then I would have imposed monetary sanctions or perhaps disbarred higher-ranking officials in the Department of Justice that had engaged in this. So I mean, his heart was in the right place. Something needed to be done, but the remedy he provided was both toothless and kind of beside the point, and may have exceeded his authority, right, where he had clear authority to impose a directly targeted sanction.
How did they find out about that? The other side?
Well, because everybody in the country knew it was being enforced. Because we're dealing with this. The DACA recipient, part of the DAPA program, took DACA, which allowed for 2-year renewals of this deferred action certificate, and DAPA extended it to 3-year renewals. So they're giving out 3-year certificates, even while representing that we're not implementing any part of the DAPA program. And so, and people were getting those certificates. So, the lawyers on the other side knew that, and they read it. They knew that there was misrepresentations, and they gave them an opportunity during the oral argument to correct it, and they stood by their guns and bald-faced lied to the judge in the courtroom.
The language of the sanctions was he didn't hold any punches.
Yeah, no, you've got. It's unfortunate that the careerists in the Department of Justice are engaging in this kind of conduct with increasing frequency. You got the big issue over in Louisiana with one of the lawyers posting sealed material up on an anonymous website to get it out there. You got the whole Ted Stevens controversy. Mike Ludig, who's the judge I clerked for on the 4th Circuit, had a run-in with the Department of Justice lawyers over their manipulation of statutory authority in briefs that was filed to him, and he just went out both barrels with him. But they continued. He actually writes an opinion in one of his cases, said the long-standing and well-honored tradition of the Department of Justice to recognize that their client is not the particular agency but the rule of law itself has entitled them to deference from the judicial branch. They are getting fairly close to losing that deference. you know, coming out of a judicial opinion, that's like both guns blazing. And then so lots of this is deeply troubling. Oh, one last piece of the Trump Muslim ban and the chaos that was created that I want to float out there. I've not been able to roll up my sleeves and take the time to figure out what exactly happened here. But I suspect what happened, and it's not good. The White House issues this executive order on a Friday. Friday night, there's a guidance memo that comes out of the Department of Justice and even the Department of Homeland Security to all of the line officers at the ports of entry, saying that this executive order applies to green card holders as well, and you're not to allow them in either. Now, the executive order didn't do that, but you've got to be deep into the statutory language to know that. It was very precise, and it tracked the language from the statute that applied only to non-green card holders. And so this memo went out, made a false claim. Now, maybe it's just ineptitude of the federal bureaucracy. I would never discount that possibility. But the fact that this was so high profile suggests to me that there may be something going on. The one area where the Supreme Court has said immigrants have a due process right to protect their property or liberty interest is when they have achieved the status of lawful permanent residents. That can't be taken away without due process procedures of hearing and what have you. Right? So if I make it sound like that order covers lawful permanent residents, I've now got a due process claim, when every other Supreme Court decision on due process things has said immigrants to this country have no due process rights to a hearing because there is no property or liberty interest in acquiring admission to the United States or a visa to admission to the United States. So no due process claim because there's no property interest unless you have a green card. So this memo goes out, I think from Sally Yates, and I can't prove that yet, directing them all to block green card holders, and then that creates the chaos at the airports. They're not letting people who have a legal right to be here in. It creates the pretext. The pretext. And of course the White House corrects that mischaracterization of the executive order within 24 hours. It gets on the Ninth Circuit, and that's part of the argument. The Ninth Circuit says, well, the White House counsel has no authority to rewrite the executive order, so we're not taking what he says worth anything. And then they press them on, and you're suggesting we don't even have jurisdiction over this case, which was the other part of revoking people who had visas. Well, the statute specifically says they have the power to revoke visas, and it is not judicially reviewable. Under Article 3, Congress can pass a statute removing the jurisdiction of the lower courts on such matters, and they have done so here in explicit terms. And the Ninth Circuit laughed that argument out of court, saying you can't limit our jurisdiction. I mean, this is a lawless power grab to undermine the result of an election that is pretty dangerous.
What do you do though if a judge says I have the authority to do it?
Yeah,
unless you're willing to impeach the judge, there's no check, right?
Yeah, so if you, given the politics in the Congress, we're never going to get an impeachment. So what other checks are there? Well, I think one of the checks is the pardon power. So let me play out the Arpaio pardon, and I've not published on this yet because I really want to get a good, detailed, deep down sense of what really went on before I go to his defense, because I might end up blowing up in my face if there's something silly. But let's make a couple of assumptions here. The thing that Arpaio was enforcing was the one provision of the Arizona SB 1070 bill that the Supreme Court upheld. And the lower court on remand issued an order telling him to stop enforcing it anyway. And he continued to enforce it because the Supreme Court has upheld it. This lower court doesn't get to countermand the Supreme Court's decision. And so he continues to enforce it. They then bring a contempt proceeding for ignoring the lower court order.
The district court?
Yeah, right, for ignoring the lower court order, for doing what the Supreme Court had already said he had the authority to do. Right? Now, if that's the scenario that played out, then I think the president's use of the pardon power to countermand that unlawful trial court order is a perfectly acceptable use of the pardon power and a check on this out-of-control lower court judiciary.
Did you try to appeal that up, though?
Well, there was an appeal pending, but he didn't want to wait for the appeal, and he got the pardon. So, and I'm not sure. So one thing I don't know, the Supreme Court upheld that provision of the statute kind of provisionally. Let's wait to see how it plays out in practice, and if they are actually doing racial profiling in its implementation, we'll allow the thing to come back. And so I want to really nail down that. But if you take the assumptions that I had said, that he was exercising power that the Supreme Court had already upheld, and in a single trial judge that doesn't like it issues an order. We've got the collateral estoppel doctrine, right? You know, even if the order is wrong, you're not supposed to violate it. Because it undermines the rule of law, right? This is the issue that landed Martin Luther King Jr. in Birmingham jail, right? The court order enjoining his march on Birmingham was clearly a violation of the First Amendment, but it was a court order that he violated nonetheless. And so he's in jail for contempt, even though the court order was wrong. Now, under the scenario I just played out, I think it would have been appropriate for the president to have issued a pardon against that contempt action as a check on that judicial illegal order, right? I mean, that's the way I think it'll play out. The other tools we have against the judiciary just aren't working. We're not going to get an impeachment of Susan, whatever her name was, down in Arizona for issuing that illegal order.
Doesn't Congress have the power, though, to restrict the appellate authority of the judiciary?
They do, but that's why...
They can say a particular issue is not reviewable.
Yeah. So
it's dangerous, but...
Yeah.
But they did in that case.
But they have in the Muslim ban. The decision of the Secretary of State to revoke a visa for whatever reason is not judicially reviewable. It uses exactly the language of Article 3 in the Constitution, and the Ninth Circuit just ignored it. And in fact, chastised the Department of Justice lawyer for even suggesting that they didn't have jurisdiction on the thing. And the Ninth Circuit's on solid ground here in modern precedent, because the same exact issue went to the Supreme Court in one of the War on Terror cases during the Bush administration. So you get the Hamdan Rasul versus Bush, or Hamdan, I forget which one it was, case. This is on the military detention tribunals, and the court orders that the president didn't have the authority to create these tribunals on his own. Only Congress could do that. So Congress passes the Military Detention Tribunal Act, which creates the military tribunals, does exactly what the Supreme Court said needed to be done, and in the passage of the act, they give exclusive appellate review to the D.C. Circuit, not to the Supreme Court. They withdraw the appellate jurisdiction of the Supreme Court as Article 3 specifically allows. That case goes to the Supreme Court. Justice Kennedy writes a decision. You can't take away our jurisdiction, right? And it was a bald-faced grab of power that in an area that they had been constitutionally deprived of authority to hear. So the problem is not just the Ninth Circuit. It's Justice. Well, I guess it is the Ninth Circuit. Kennedy came up to us from the Ninth Circuit. I'll take more questions if you want, but there's a funny story. When I was at the court, that was the year we had 28 cases from the Ninth Circuit, and all 28 were reversed. 26 of the 28 were reversed unanimously. So I mean, this is they are so far out, they're not even getting Ginsburg and Breyer on board with them, right? So we got tired of writing the same conclusion of the opinions. The decision of the Ninth Circuit is reversed, the opinion of the court is unanimous. So we wrote an Alt 9 macro. So you just hit Alt 9 and it typed out automatically.
Oh, that's great, John. Thank you so much.
Oh,
I appreciate it.
Thank you.